secrets and know-how. They are just focusing on patent, trademark, copyright.
Yeah.
But there is no enough information about even in the IP laws, and regulations, there is no enough details about the trade secrets, the know-how, how to protect it. So they are not encouraging companies to register. So what is your comment on that? How we can encourage companies to register their trade secrets and know-how? The same way they are doing for patent, trademark, and copyright.
Yeah, it's a confounding issue. You know, we've thought about it for years and tried to, I think someone mentioned WIPO proof as this blockchain solution that WIPO put out, and it kind of came and went pretty quick. I'd say number one, follow the money, right? How do I explain this away? Well, you know, the US Patent Office doesn't have any way to make money from a trade secret, right? Absolutely none. So guess what? You know, I have, you know, on LinkedIn, and anytime anybody will listen to me, I'm like, look, you have a duty, you know, to this country to figure this out, right? And you know, honestly, I think a lot of people would probably pay the USPTO to stamp something as a trade secret, right? I don't think that's a crazy idea. I think you just gotta have the systems to be able to do it. So I think what we'll see, and I don't know if it's Dubai, UAE, if it's Singapore, somebody that's nimble and quick and can make decisions is going to just figure out how to do it, right? And then that's going to, you know, kind of encourage other governments to kind of understand, hey, that, you know, not only should we be doing this for the, you know, betterment of the society, you know, we have a model to monetize it as well, right?
So the main challenge is that how to make money of that, or they don't have the technicality how to protect it?
Well, I think it's number one, money, okay? And then number two is expertise. And so, again, I've had to become an expert in trade secret law, and I'm not a lawyer, by the way. I'm a chemist by training, and I've done a lot of IP licensing, so I've got a strong contracts background. And I just had to go deep into the case law, right? And our whole team. And I think what you see in the average, probably patent examiner at the USPTO, as I'll pick on, they have no idea about trade secret law, right? They couldn't tell you that Appian case, they couldn't tell you the L'Oreal case, you know what I'm saying? So therefore, they're not in a position to become a champion or to drive it forward, right? So I do think there's a whole community. We spend a lot of time with young lawyers, right, in law school, saying, you know, think about trade secrets. It's wide open. All of your sort of patent counterpart, you know, that have been doing this for 10 or 20 years, you know, they don't either care about it or want to care about it. So there's an opportunity here, right? And what's neat about it too, from a young lawyer point of view, is that you don't need to have a deep technical background. This doesn't take a PhD to become a trade secret attorney, right? You need to, you know, be able to drive process, right? It's really a lot of process. And I think as the tools get better, you know, as we can go from our predicted trade secrets off into search, right? So right now we're going from there to generative AI, and now we'll go from there to search, right? So quantify exactly how good of a trade secret this thing could be, for instance, right? And that's not that far away. I mean, it's not 10 years, you know, it's inside of 5, and there's going to be some super cool stuff going on the software side. Abdurrahim? Yeah. Thank you. Are we okay at time? All right, with a panel of two, it could seem like a little bit of an interrogation, and so that's not why I'm here. But I would encourage anybody to jump in and ask questions or make comments, please. So maybe Abdurrahim, start with an intro and a little bit about the company.
Yeah, sure. It's me, Abdurrahim. I'm an in-house counsel at custody for Arabia. We are basically a trading company. We buy the car and sell the car. We don't do any IP things. We don't do anything different what other people do, but though we have we call a kind of trade secret that makes us different from other players in the market. That's a brief about me. And I will start with the question from Mr. Ahmed regarding the mechanism for trade secret protection. In my knowledge, these are things which need to be acted from the policy level or the kind of legislation level. Because unless we have a kind of mechanism for protection and safeguarding the things, our whole discussion is just like an academic discussion. It won't bring any result. So for me, it is more important to have a kind of mechanism for protection of trade secret. But I also heard that there was a kind of discussion in the Japan to have a mechanism kind of called idea banking. If you have some kind of idea, you can deposit in the idea bank, then no one will come across with that. But though it is not developed as a kind of mechanism and no global attention has been received for this idea banking system. So just for a comment, I think it's a matter of policy and matter of regulation and a system by the governmental level.
And so I think at the core, you're a trading company, but a software company?
We are a marketplace for buying, selling, and auctioning, and many other services related to automobile industry. And in one word, we are a marketplace. If you want to buy or sell, you want to auction, you want some value-added services, if you want to hire a driver, we have everything on the platform. So idea behind our business was when you want to buy a car and you want to sell a car, you have to suffer a lot, you have to struggle a lot. So to avoid that, we provide a mechanism where while being at your home, you can sell and buy. That's the idea. So in the one aspect, definitely it is a software thing, and the other aspect, because there is a physical movement of the things. So definitely there is a trading aspect of it as well.
So so first maybe just start with UAE and sort of the trade secret sort of regime here. Any insights in terms of what the law says here? How easy is it to impact legislation or impact litigation here? I think certainly for some of us in here, it would be good to just get the 101.
When you were going through your presentation, I felt like if you are presenting this aspect in front of the, not of the selected crowd, in front of the public, you must have received a lot of questions. Because this is the one area, because I come from a mixed background of in-house practice and a law firm practice. Because in my good time, around 6 years, I spent with the law firms as a private practitioner, then moved to an in-house, taking care of legal aspect of and compliance aspect of the companies. So what I found is trade secret protection is one of the burning topic here. But I have not seen that enough attention has been given by the organizations, unless these are the big MNCs things, they take care of very serious note of it. Otherwise, when we were in the law firm practitioner, we have seen a lot of cases where the lawyers have no option other than billing. The clients have come out with bundle of questions and end up with your figures like there is a lack of evidence. And because trade secret is something, as you rightly explained, that is purely a contractual obligations. And if you don't build a contractual obligations, or there are a few other elements which is as a sine non for the trade, kind of trade secret protection, then if this all things are missing, there is no point of creating an action. Because as per UAE law, there is not trade secret law.
Just contract.
It is coming under the federal law, but it is very well integrated in multiple legal professions. Because if you take example, a person has committed a breach of trade secret or violated a trade secret or committed a kind of crime, it can track into that aspect as well. Because an act which constitutes an offense can also be a crime in a way that when a person is disclosing a confidential information of the company to other party, which was which constitutes as a trade secret, then it's an offense. We have seen cases where, as you rightly said in the in your talk, that it's a bad behavior, because when the matter reached to the court, because when it reaches to the court, judges has no option other than looking into the law and to the facts. But it would be clearly established that the person who committed the offense has disclosed the confidential information, which was really a trade secret, but the petitioner failed to prove it was a trade secret. Number one. Number two, regarding the identification of confidential information. What constitutes confidential information was not rightly identified. Then the third thing comes contractual obligations. You executed a contract which was not in accordance with the law. Because we have seen a practice here is when it comes to the small companies or small medium level companies, they make a contract and they use it for everybody. And second thing is you form a contract because there is a vibe coming from the Europe and America, and people use a contract and you put a jurisdiction clause in Luxembourg, and you are going for a legal action in the Dubai court. It's very easy for the opposite party. There's a non-jurisdiction, or you put an arbitration in London, and the other party, the petitioner, will argue from the point of crime and criminal offense under the cheating or breach of trust, a lot of things like that. But again, how you are going to establish it? Because to constitute a crime, as we all know, criminal intention is very important. And duty to have a, duty to follow a confidential kind of duty is not easy. To establish it is not easy, especially in the absence you don't have a proper documentation. But if you take the local laws, especially in the UAE, we have three kinds of jurisdictions. One is the local laws, and then we have a DIFC law, and we have a ADGM law. DIFC and ADGM has a very good trade secret law, but that's not generally applicable to every companies. That is applicable to only the organization which are within the jurisdiction, and or where there is a vested jurisdiction. But in the absence of that, it's very tough to establish. However, the DIFC law is very strong, and there is a proper mechanism to address the issue and all.
So you're making me think of two things. One is the benefit, the beauty of the U.S. system, at least from trade secret point of view, is discovery. So finding the paper trail of intent. I continue just to be fascinated at these cases where you see presumably really high IQ, smart people creating a paper trail that just sort of like takes you right to the answer, right? And it's happening, like there's an important case every month that you can say like, wow, that person was a complete idiot, like, do they not know email servers like last forever? So, and then we used to talk about the law firm, what we see, and I think one of the things that gave me a little bit of confidence to get this company started was in the early days, talk to these IP attorneys who would, their clients would say, hey, can you help us with trade secrets, right? And I think where they just sort of fell flat was like, well, send us your NDA, and that was sort of the end of the story. And so we've kind of taken it upon ourselves to make the law firm, help the law firms figure out what it is that service should be to the client, like over and above the contract, right? And I think a lot of that documentation, what's good enough, I think I would just sort of encourage everybody to say, it's really policy dependent, right? So your policy should say something about what you're going to go do to manage this stuff, and then just follow the policy, right? And so you don't have to strive for perfection, you just have to meet the sort of the word of your policy. So on software, and the reason I ask that is, I'd say more often than not, like most of our customers are not software companies. It turns out mostly in biotech, life science, chemicals, but we're starting to get some software customers. It's interesting to see there's sort of been an uptick in understanding, but I'd say there's a really good case from the U.S., which is, it's basically it's a quintessential case where the company just didn't think they had trade secrets because it was basically a bunch of open source code that was comprising their product, right? But even open source code put together a certain way in and of itself is probably confidential unless you've sort of published a function diagram somewhere. and it's protectable by trade secrets, right? So I guess in your company, well, maybe just tell us a little bit about sort of procedures and how you treat, how you treat code, for instance. Any learnings you've had from past employees that maybe misbehaved. I think anything along those lines would be interesting to hear about.
I don't think will there be any company in the region which has around maybe the minimum 10 or 15 years of standing in the market, missing this kind of experience, because it's very, I'm not saying it is very normal here, but there are instances in the region, especially for us also, we have come across with a situation where the employees have been caught with inappropriate behavior. I cannot say it was a crime or it was a failure of contractual obligation. It was inappropriate behavior from an IPR protection point. Because we have a system of when an employee get on board or when an employee get exit, we have a policy arrangement where there is adequate measures have been taken to protect the IP things and protect the data mainly, that is very important now. And then regarding the disclosure of confidential information in respect of, I won't say it again as a trade secret, I would prefer to say it's as a know-how, because we are not selling something product, because our way of doing business make different for us. So the know-how, how they know how to get a maximum protection and how to, how to secure ourselves and how to make sure that employees also should not feel that I'm under the rigid scheme, because every employee, whether he's working or has previously worked with us, our flag bearers tomorrow. So in fact, we want to support them, because it's not necessary that once you join for an organization, you should work there, for your lifetime. Because as an employee, you will have your own, you'll have your own dreams, how to grow and things. So we don't have a system where the employee will feel a kind of rigid skin. But however, we are more concerned about our know-how, and we have adequate measures on place in the form of contractual obligations. And more than that, we are a little more vigilant about disclosing the information things. But I see a more challenge for tomorrow in the region is regarding the data protection. Because how you are handling the data in the regional level as on today is not in a standard way. For example, I'm having an Emirates ID. If you are from the region, you know what is Emirates IDs. As a law practitioner, I may have so many Emirates IDs in my WhatsApp. How it's reached me. It's very important information of someone else. Though as an in-house counsel, we say no, it's confidential, we cannot disclose, but it is circulated throughout the market. It's not a case of my organization or someone else's organization. It's very regular. This example is not from my organization, but it's a very regular practice in the market. So I see, challenge of today and tomorrow will be regarding the data protection, how you are going to streamline it. But as a local regulation perspective, we have a data protection law. It's already enacted. The regulations are yet to come. So, but it will be a challenge how you are going to handle it.
I think that's really cool how you framed up the employee. They have their own dreams. They're not going to be working for you forever. That's great. And I heard a GC from a biotech company in the U.S. talk about this idea of saying, they apply a very rigid standard to their trade secrets. But the way that she's able to kind of frame it up to the employee is that this is going to help you get your next job. You have lived through, working for this company that has this incredibly high standard. It's going to differentiate you, And man, listening to her say that, I was like, that's pretty cool, Maybe something there.
There is one pharmaceutical company in the region. There are more than so many branches. I don't want to give any data where you will be able to identify them. And one of my colleagues was saying that once you have worked with that pharmaceutical company, then it is a proof that you will never be unemployed. You will get job somewhere. Because it's a certificate for you that you can go through every kind of pressure, and you are fit for the industry.
Yeah, that's cool. And what about this whole large language model thing? In the US, we see Microsoft was most recent to sort of put a shutdown. And funny because, you know, an OpenAI investor put the shutdown on ChatGPT internally. We talked with some folks earlier that, you know, bigger companies are generally kind of just sort of shutting it down, right? Because the risk is too high. Samsung, Apple, there are a few other companies over the last, you know, year where either their code is showing up in places it shouldn't be or other kind of confidential data. Is that something you worry about? Is that you guys using those models, or are the developers, you know, using them to write code?
This is not my worry as in today, but it's really a worry for my product team because they are the people working on this sector today. But definitely ChatGPT things, according to me, it will create certain disruption in the market as it is doing now, but it will have a more legal challenge. Again, I'm not sure about how the legal framework is going to address it. Because it is easy to say, I will do that, I will do this, and we have this mechanism and all, but at the end of the day, when it comes to the legal scrutiny is something where they cannot rely on the presumptions, though presumptions are very important. And under the local legal framework, there are two aspects. One is definitely a criminal aspect, and then there is a civil law remedy aspect and a solution aspect. These all things, they cannot be worked together. A separate action needs to be initiated. So every action has its own requirements. So according to me, it may not be easy. They'll have a lot of challenges, but I expect two kind of situation here. One situation, the things can be established very easily, and second kind of situation is like with a lot of confusions. Because we have seen a situation in some other industries where the matter went to the court through a process of dispute expert practice level. Means there is a local practice where if you are not confident that there is a case, then you can approach the expert. Then the expert make a case and give to you. But this entire, usually we have a 3-tier, but it carries the 4-tier litigation level. Everywhere it creates more and more confusion. Because as I explained to you, in this all three level, there is a different ingredient for everything. So I'm not sure how you're going to solve it, but definitely a best practice principle will play a crucial role in it. So I think the organizations should have a proper mechanism to address it. As a contracting professionals, we always say that you should figure it out everything. Even if you say you will lose at the end of the day, no problem, but figure it out. Don't keep the pupil or don't keep the organization in a way that tomorrow people will be in an uncertain situation. So according to me, to face this situation, as an organization level, the organization should figure it out, what should be and what should not be, and should involve better software or better SaaS services and better DaaS services to secure the things.
Yeah, just to follow up to that, so we developed some AI to analyze contracts, and so as we're training the model, one of the things, amongst our in-house lawyers, I said, okay, here's some language around trade secrets, and it was a definite trade secret definition, and it was just funny to me how one of the lawyers basically said, yeah, let more definitions better, right? You leave less room for interpretation. And another very reasonable guy on the team said, no, you should leave it open. It's fine. There's more leeway, right? And so I was like, well, I don't think it can be both, unless you have it to be tunable. But I think the only thing I would encourage. There's an article. I don't think I mentioned it, but Shopify, the Canadian web service company. They just announced last week some technical achievements with their large language models, and they're using Microsoft's Copilot product. And just go read that article, because it'll like blow your mind in terms of like what's coming in terms of productivity, especially in software. It's just unbelievable the amount of productivity that these kind of firms are already achieving. So yeah.
I have a question regarding the open source and trade secret.
Yeah.
So you mentioned about a case in US. So
Yeah.
could you elaborate on that? In the times of open source, how do you make sure that the trade secret is also maintained?
Yeah, it's a good case. It's called Earth Solutions, IRTH. There's some good reviews written about it too. And so the effect of the case was really, here you have a bunch of open source functions, right? Maybe a couple functions in the software that were proprietary. So if you can imagine, simplify, we have 20 functions in the software, 18 are open source. So everybody can get their hands on those, right? They can learn about them. But what they don't have, or don't have access to unless they come upon it illegally, is they don't have how it all works together, right? And the stitching of all those functions together, and that's really in the form of some kind of function diagram, right? So basically what the court said, so again, it was one of those cases where an employee left, went to a competitor, stole everything, and the court said, hey, sorry, you never wrote, there's no function diagram that is labeled confidential. That was essentially it, right? That's all they had to do. It was like maybe 15 minutes of work, and they would have won the case. You know, so it's those kind of things that everyone's just now starting to kind of come to terms with. But yes, I mean, you know, it depends on the open source license itself. But yeah, I mean, you don't need to go back to the open source community and tell them all your details, right? I mean, yeah.
First of all, thank you so much for this one. Actually, I can understand the concerns that Mr. Ibrahim just raised now about what they are facing regarding the trade secrets and all. But I think this will be solved very soon in UAE, because recently, 2021, UAE has upgraded and amended most of their laws and regulations. More than 50 new laws came, and there are 3 laws for IP, 1 for copyright, 1 for trademark, and 1 for patent. But there is no separate or independent law for trade secrets, but in the patent law itself, there are few parts specified for trade secrets, integrated circuits, and I think for what we call new plant varieties, and for some kind of species. 4 categories are there. So trade secrets are there, and it will be registered. They have a new system now, I think. They have upgraded their system. Before it was not there. Now it's there. You can apply for the protection. It will require some documents, some information from your side, so you can have the same. The same thing for integrated, what they call integrated circuits. If you have some system for your company, and it happens with us also with some companies that the employee will leave the company, go open his own company or join another company, and you will find the same source code, the same, what we call the same system, everything. So if you have protection, you can take action. So the situation will be changed soon. I think now they start already on 15th Jan. They have started the new system, accepting the filing of trade secrets, integrated circuits, new plant varieties, this kind of thing. So now you have the option to do it, which is not happening before. So most of your concerns will come. And I think what you mentioned about the company's policy, company's relation with the employee, most of the companies now, they have their own policy. General policy with all employees, and also they have some kind of labor contract. Apart from the labor contract with the Ministry of Labor, they will have their own agreements, internal agreements with the employee. As you said, when he comes on board, when he is leaving, what you will do, what you shouldn't do, what will be the penalties if you do this, if you do that. So this also should secure the company for future. If he leaves the company and do something from these things, he knows in advance, and the contract, you can submit the contract to the court, and it will be very strong proof for yourself.
I love these conferences with like free legal advice. It's great. Thank you. It's awesome. It's a great perspective. I'd like to learn more on that as well. Oh, one more. Yeah.
It sounds a little bit of a silly question, but do you think that filing provisional applications in the US and just let it go and expire, would that can be a way of challenging as a trade secret in court?
Yeah, it's not silly at all, just so I could encapsulate it. So you file a patent and then you abandon it, but you've established record?
It never published.
Yeah, exactly. Actually, companies do it.
Oh.
It's a well-trodden strategy. Not a lot of companies, but you'll run into people that do it. It's not a bad idea.
But court accepted.
I'm sure there's cases that show it, but I don't have any off the top. The other thing that I should also note, I was at a conference a few months ago, and a few big Silicon Valley tech folks there, and one of the things that they were talking about is using generative AI alongside the patent. So they'll draft the patent, right, and then they'll file the patent. And so again, you're confidential for however many months, and in that time frame, they'll run Gen AI on the patent, right? And again, you got to be careful how you do this. You don't want to just throw it into GPT, but then they will use the large language model to help them predict derivative stuff or blocking things that they didn't think about. And then they will sort of proactively publish that stuff. So they get all of that blocking art like ready to publish. So when the patent application publishes, the very same day they click, and then all of this blocking art they just put out in the open. And I thought, like, whoa, that's pretty smart, and it doesn't take much to do it. So it's something to consider. Yeah.
So the benefit is only that you get a priority.
So you get a priority. You'll get like probably the best priority you can get. Yeah. Now, again, you could get that same priority by just having good documentation process in house, right? And you name the database, and look, it was in this database on this time. The courts, it turns out, there's a lot of talk of blockchain over the last few years, and we talk a lot about this topic. And really, at the end of the day, the courts just want to see that you've done something. They don't care if it's like a napkin or a piece of paper or a fancy, database or blockchain. It doesn't really matter. Just sort of show us something, right? So I think the patent thing is definitely overkill for what the courts look for, but definitely people use it. Any other questions? Good on time.
Any other question from the audience? Okay, we have one question.
So, under Cyprus law, there is legislation which protects trade secrets, and there are 3 elements in order to be eligible for protection. The third element is that the owner has took reasonable measures in order to keep safe the information. So my question is the following. Since employees are having fiduciary duties to their employers, including the duty to not make secret profit and the duty for loyalty. And since they cannot walk away from the company and pick up a computer, or they cannot pick up some pens, the fact that the employer made sure that those information will not get outside from his firm are not enough in order to qualify for protection. He has to put on them privileged or classified. I mean, it doesn't go without saying that everything is classified. That's the question.
I think I can definitively say that the U.S. courts, and more lately than historically, I think the sentiment around trade secrets more than 10 years ago would be, look, have good confidentiality provisions, right? Whether employment agreement, NDA, whatever. Make sure those are good. And have some kind of like InfoSec capability. You got passwords. Okay, good enough. And you should consider everything trade secrets. So, and I think what's happened since that quote I put up 2014 to today is like this idea of particularity, right? And I think the problem is because, well, if you think everything's confidential in the business, then, well, probably nothing is, because that's just sort of a hard practice. And the reality is a bunch of stuff sitting on, my Dropbox, half of it's PDFs I downloaded from the internet, It's not confidential. So the whole, so I think that's where companies have gotten into trouble, and the whole thing has just gotten more complex, is because it's just impossible to sort of say, everything's confidential, And so I think in the US, the courts are definitely pushing more on this idea of particularity. And you also see in the US, controlling people through the non-compete agreement. So in the US right now, there's a measure from the FTC to ban non-compete agreements. And so I'd say historically, the idea would be I control the person instead of controlling the data. And so if I can control you from not going to a bunch of competitors, same difference, right? But the non-compete agreements are out of favor now. California doesn't, you can't litigate them in, I don't know, 8 or 9 states. And so, anyway, I think the courts have kind of spoken in the U.S. that, that particularity matters.
Do we have any other question?
Thanks, everyone.
Thank you so much.
Awesome. Yeah. Get our award. I'm not leaving without a trophy.
Thank you so much. Thank you for making this session wonderful, especially after the lunch break.
You need a loud American right after lunch, Very purposeful. Awesome. Thank you.
You can have
One more. This is Instagram.
Thank you so much. So, now let's have a last session, which is going to be the open round session on copyright and content creation. So, it's an open round. You can talk about any topic, discuss about any topic. So, who's going to be the first?
Is this like open mic?
Anyone, please? Okay, we'll start from the exit. So it's an open round. You can discuss about anything related to the copyright and the content creation.
Just copyright?
Yeah.
Okay.
Does anybody have any thoughts on AI? Like
Especially the ChatGPT and the BART issue.
This is what I want to talk about.
Awesome, cool. I'd love to learn.
Actually, recently we have attended many workshops and many sessions about how to use AI in creating new works. And the challenge was in different aspects. The first one is, if I use any AI device or machine or whatever, or software to create a new work, first of all, this new work, who will be the right holder? Is it the machine itself, or the user, or the manufacturer of the machine, the developer? We have a lot of questions regarding who will be the right holder, who will be the author, who will be the creator.
Yep.
If I want, for example, if this new work is infringing some other copyrighted works, I want to take a legal action. Who I can